Are you confused about the e-privacy rules on B2B emails in the UK? Well, in the time it takes to have a cup of tea, we'll set them out clearly. And stick around because we'll put up a table summarising those marketing rules from the UK ICO. Hi, I'm Robert Bohr, the founder and CEO of Keepable, the award-winning solution saving you time, money and stress on all things privacy, giving you a great answer for the board and customers. This video is part of Privacy Kitchen, free video help on GDPR and all things privacy. So if you're new here, please do click subscribe. Links are in the notes as always. Okay, B2B email marketing in the UK. We saw in another video that these are in what's called PECR, the UK's Privacy and Electronic Communications Regulations. That's why we call it PECR, not GDPR. And PECR's UK law, so it will be with us post-Brexit. Now it's really PECR then GDPR because GDPR will set out the rules on consent, the rules on legitimate interests, and obviously how you interact with processors and this sort of thing. But the rules are in PECR. Now in summary, you do not need consent to send B2B marketing emails, namely marketing emails to an individual work email address and a legal entity where the legal entity is the target of the marketing. We also saw in our B2C video that the detailed rules in PECR's Regulation 22. You cannot send unsolicited emails for the purposes of direct marketing to an individual subscriber without their prior consent unless a soft opt-in exemption applies. Now we won't go into unsolicited emails and for the purposes of direct marketing, they're covered in the B2C video, do look at that. The part that matters here is individual subscriber. This is the part we think causes the most misunderstanding. Individual has a clear, immediate meaning. We're not talking about legal entities like a limited company, a PLC or an LLP. But for these laws, it also includes sole traders and unincorporated partnerships. Think of it that there's no legal entity in the way, so the marketing has to be directed at one of those individuals when you market that business. Now, subscriber is trickier because it's not a subscriber to your service. It means the person party to a contract with a provider of public electronic communication services for the supply of such services. So it's the services over which they're getting that email. So let's go back to that test. You cannot send unsolicited emails for the purposes of direct marketing to an individual subscriber without their prior consent unless a soft opt-in exemption applies. It's those two words, individual and subscriber, together that means that the consent requirement under UK's PECR does not apply to marketing emails to a non-individual subscriber. Again, this is all under UK PECR. Member states' laws, you'll have to look at the law that implemented the e-privacy directive in your country. As always, we love examples, we know you do, so here's a couple. Take the email firstname.surname@companyaa.com. That person works at Company A, and Company A, the legal entity, is a subscriber for all the services through which that email is transmitted, etc. Yes, that email is definitely personal data. It identifies that individual. That individual can unsubscribe from that email, and you do need to provide an unsubscribe facility. But the subscriber is not an individual subscriber, it's the legal entity. Now, I grant you, not all business.com emails are legal entities, but it's a strong indication and you'll need to check. Perhaps you've got a policy of only marketing to legal entities or only taking on legal entities as customers, and you check before you do so and add them to your database. Just a quick note, emails such as info@companyaa.com or hello@keepable.com, for example, they're not personal data, so PECR and GDPR doesn't apply to those email addresses. Right, second example, with the email firstname.surname@hotmail.com, the individual is most likely the subscriber and PECR's consent rules are most likely to apply. Yes, businesses may use Gmail, Hotmail, etc., and you won't be able to tell without more due diligence. So in practice, it's recommended to assume all Hotmail, Gmail, etc. emails are individual subscribers unless you know otherwise. So you don't need consent for B2B marketing emails. Now this can be an explosive topic, so let's look at it in some more detail. The UK ICO's draft direct marketing code of conduct, still draft as at the end of May, is clearer on this, saying consent isn't necessary for emails and text messages to business contacts and corporate subscribers. And it goes on to give examples that confirm this. This continues its guidance, for example, in its direct marketing checklists, and all of these links are in the notes below. But the clearest position is in their advice to consumers on spam emails. Admittedly, this was before GDPR, but in that they note, and I quote, "The rules on email marketing are different if the marketing is being sent to a corporate email address. If you work for a corporate body, that is a company, a Scottish partnership, a limited liability partnership, or a government body, then organisations are allowed to send marketing emails to your work email address without your consent." That's a quote from the UK ICO. Now, a quick search will show you lots of law firm briefing notes and legal resource entries acknowledging this. Now, yes, of course, that person's work email is personal data under GDPR, but under the email marketing rules in PECR, which take priority on when you need consent and when you don't to send unsolicited marketing emails, you do not need consent when that work email is of a person at a legal entity and you're marketing that legal entity. You'll probably rely on necessary for legitimate interests. So do perform a legitimate interest assessment to make sure that your interests on the one side are not overridden by the rights and freedoms of the recipients on the other. And although it's not a rule set out in PECR or the Privacy Directive, the UK ICO says you can only use legitimate interests for B2B emails sent to people to whom your emails are relevant because of their role, which makes sense. Now, this B2B part is the big emotional issue with PECR, and roughly half of Europe have followed implementation of the 2002-2009 EU e-privacy directives like the UK, and half like Germany, which is much stricter. And really a lot of the big arguments come into the use of the word subscribers and individuals, particularly in that 2009 version. This is why we really need that draft e-privacy regulation to replace the e-privacy directive, but it's been bogged down in drafting stage and lobbying for years now. As you can see, it's quite contentious. But we'd really welcome having clarity here and the same rules across Europe. It would really help everybody. At least for now, the UK PECR and the UK ICO's position are quite clear. Now here's that quick guide I promised. It's the UK ICO's at a glance guide from 2019, and the link to this is also below. So there you go, B2B email marketing to individuals at limiteds, PLCs and LLPs, for example, does not need consent. You'll look to rely on legitimate interests. Now do have a look at our B2C email marketing video. Please do visit us at keepable.com. We've got a great privacy policy pack, including privacy and marketing. Please like if you enjoyed the video, and do use #PrivacyKitchen to tell us the questions and topics you want covered. Stay well in the meantime, and I look forward to seeing you again in Privacy Kitchen soon.